Welcome to K&L Gates Working Wise podcast series. My name is Ryan Redekopp, and I am a partner in the Seattle office of the firm's Labor, Employment, and Workplace Safety Practice Area. In this podcast, I will discuss some of the major workplace considerations related to the opioid epidemic, including potential signs that an employee might be suffering from addiction, considerations related to drug testing and drug-free workplace policies and practices, and issues related to disability accommodation and job protected leave laws. So, what is the opioid epidemic? This phrase refers to the rapid increase in the use and abuse of prescription and non prescription opioid drugs in the U.S., beginning in the late 1990s and continuing through the present. Opioids are a diverse class of painkillers that vary in strength, including oxycodone, hydrocodone, fentanyl, morphine, and heroin. They are potent and widely available, making them popular for both medical treatments and as recreational drugs, despite their high risk of addiction and overdose. In recent years, drug overdoses have become the leading cause of death in Americans under the age of 50, with a majority of those deaths caused by opioid overdose. The opioid epidemic cuts across ethnic, socioeconomic, gender, and age categories. The depth of the problem has become a nationwide focus, with President Trump declaring it a public health emergency in late 2017, and the U.S. House of Representatives recently passing a bipartisan package combining 58 bills addressing a wide range of opioid-related issues. So, why do employers care about the opioid epidemic? In short, employers care because of the significant costs to their businesses, and they care because the opioid epidemic is impacting the health and well-being of their employees and their employees' families. Focusing on the workplace, opioid abuse and addiction can cause attendance problems, morale problems, huge drains on performance and productivity, increased turnover rates and retraining costs, theft of company and employee property, injuries or fatalities, property damage, and increased workers' compensation and healthcare costs. Unfortunately, absent drug testing, which will be addressed later in this podcast, opioid abuse can be very difficult for employers to detect. Opioid pills generally have no odor, and employees may go to great lengths to hide their addiction. Oftentimes, employers may not become aware that there's a problem until after a significant incident occurs, such as a workplace accident. According to the Job Accommodation Network, or JAN, which is a service of the U.S. Department of Labor's Office of Disability and Employment Policy, there are some common behavioral characteristics that often arise in connection with drug addiction, including absenteeism, absences without notification, and excessive use of sick days, frequent disappearances from the worksite, long unexplained absences, improbable excuses, unreliability in keeping appointments and meeting deadlines, work performance that alternates between periods of high and low productivity, mistakes made due to inattention, poor judgment, and bad decisions, confusion, memory loss, and difficulty concentrating or recalling details, ordinary tasks requiring greater effort and consuming more time, interpersonal relationships with coworkers suffering, rarely admitting errors or accepting blame for errors or oversights, progressively deteriorating personal appearance and hygiene, wearing long sleeves when inappropriate, personality changes like mood swings, anxiety, depression, lack of impulse control, or suicidal thoughts or gestures, and increasing personal and professional isolation. Now, employers must exercise caution, however, in jumping to a conclusion that an employee is suffering from addiction simply because he or she is displaying some of these characteristics. Many of them could be signs of other medical conditions or disabilities. Nonetheless, management training regarding these signs can help employers to identify potential substance abuse situations in the workplace early, to avoid major incidents, and ensure that employees receive help before the situation worsens. So let's turn to drug testing and drug-free workplace policies. Effective January 1, 2018, the U.S. Department of Transportation drug testing requirements were updated to require testing for several semi-synthetic opioids. Now, employers who are not subject to those or other detailed federal regulations mandating specific drug testing procedures should also take a close look at their drug-free workplace and drug testing policies and practices to ensure that they're up to date and adequate to address modern issues related to the opioid epidemic. The first issue that employers might wish to consider when evaluating their policies and practices is whether to begin conducting some form of drug testing if you're not already doing so, or whether to change the types of tests you conduct if you already are doing some testing. Now, potential testing options may include pre-employment testing, periodic testing, randomized testing, post-accident testing, for cause or reasonable suspicion testing, return to duty testing, and follow-up testing. It's important to note, however, that not all types of drug testing are permissible in all jurisdictions. Particularly if you're deciding to implement drug testing for the first time, or if you're expanding your operations into new states, it's critical to work with employment counsel to ensure that your drug testing policy and practices are fully compliant with applicable state-specific drug testing laws and regulations. They can vary widely between jurisdictions. Employers conducting drug tests should also consider whether their tests are actually screened for synthetic opioids like fentanyl or other semi-synthetic opioids like oxycodone and hydrocodone. These substances are not detected by the standard 5-panel tests used by many employers. Especially if your testing includes screening for opioids that may be lawfully prescribed, it's highly recommended, and in some jurisdictions it may be required, that your testing program utilize a medical review officer. Now, this is a licensed physician with expertise in reviewing and analyzing drug test results who reviews any positive tests and gives the employer applicant an opportunity to confidentially explain whether there is a lawful reason for a positive drug test before it's reported to the employer. Choosing to implement some form of drug testing may be a particularly prudent way to limit risks and liabilities for companies with safety-sensitive positions where an employee abusing opioids could injure themselves or others on the job or cause extensive property damage. On the other hand, employers in some industries may determine that drug testing could itself become a liability when viewed in the context of a tight labor market and fierce competition to recruit and retain talented employees. Employers concerned about those issues might choose to forego drug testing and to instead focus on education, prevention, and treatment or rehabilitation measures. Such measures might include educating employees about the risks of prescription drug abuse and alternative methods of pain management, training supervisors to recognize the signs of impairment and abuse and how to respond to it in the workplace, promoting and leveraging employee assistance programs to help employees get treatment and return to work, and ensuring that medical benefit plans offer alternative pain management options like acupuncture, massage, physical therapy, and chiropractic care. Of course, there's no reason that these measures couldn't also be implemented alongside a robust drug testing program. When reviewing written policies regarding drug-free workplaces and/or drug testing, employers should ensure that the policies include clear and detailed descriptions of all prohibited behaviors, all drug testing procedures, and the consequences for any policy violations. One specific issue to consider is whether your policy expressly prohibits the use of opioids or other controlled medications without a prescription. Policies should similarly address issues related to the lawful prescribed use of opioids and other medications by employees. One potential approach is to require that employees consult with their physician or pharmacist to determine whether a prescribed medication could interfere with the employee's safe performance of her job, and to state that employees are responsible for using appropriate personnel procedures to avoid unsafe work practices while taking the medication. For example, calling in sick, using leave, or requesting a change of duty. Now, that last point leads into another major issue related to the opioid epidemic in the workplace, which is that employees and applicants may have certain protections and rights in connection with their lawful use of opioids and obtaining treatment for opioid dependency. Employers must use caution when managing employees who are lawfully using prescription drugs, obtaining addiction treatment, or who need time off to care for family members who are obtaining treatment related to opioid addiction. The first major federal law to consider is the Americans with Disabilities Act, which prohibits U.S. employers with more than 15 employees from discriminating against qualified job applicants and employees because of disability. There are many similar state and local disability discrimination laws that apply to even smaller employers and which also may need to be considered. Under the ADA, an individual is qualified if she can perform the essential functions of the job with or without a reasonable accommodation. The ADA does not protect employees or applicants based on current use of illegal drugs. The ADA does, however, generally protect individuals who are participating in or who have completed a drug rehabilitation program if they are not currently using drugs illegally. Reasonable accommodations for employees participating in drug rehabilitation programs may include time off for rehabilitation treatment or a flexible schedule to allow the employee to attend counseling, doctor's appointments, or support group meetings. The ADA may protect individuals who lawfully use prescription opioids to treat a covered disability. If an employee informs the employer that he or she is using a prescription opioid that could interfere with the performance of essential job functions, an employer generally cannot automatically terminate the employee or rescind a job offer on that basis alone. Instead, the employer must first engage in an interactive process with the employee to determine if a reasonable accommodation is available that would enable the individual to safely perform those essential functions without causing the employer an undue hardship. Reasonable accommodations related to lawful opioid use might include unpaid leave or modifying the employee's job duties. On the other hand, where an employer has no knowledge that an employee has a disability and is using prescription opioids, the employer may be able to hold the employee accountable for unacceptable job performance attributed to the prescription opioid use if it occurs before the employee requests a reasonable accommodation. Another defense available to employers under the ADA is the so-called direct threat defense. A direct threat means a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. A direct threat determination requires an individualized assessment of the individual's present ability to safely perform the essential functions of the job based on a reasonable medical judgment that relies on the most current medical knowledge and/or on the best available objective evidence. Because this defense is narrow, highly technical, and requires more than just an honest, good faith belief that an employee poses a safety threat, employers are strongly encouraged to consult with counsel before taking any adverse employment action against an employee or an applicant based on a direct threat determination related to the lawful use of prescribed opioids. Another significant federal law that could be impacted by opioid-related issues is the Family Medical Leave Act, which generally applies to employers with more than 50 workers and allows eligible employees to take up to 12 weeks of unpaid, job-protected leave because of their own serious health condition or to care for a spouse, child, or parent who has a serious health condition. As with the ADA, there are numerous state and local laws related to paid or unpaid time away from work for family and medical-related reasons that may also have to be considered. An employee may be eligible to take leave under the FMLA if he's been employed by the employer for at least 12 months, has worked at least 1,250 hours for the employer in the 12 months prior to the start of FMLA leave, and the employer employs 50 or more employees within a 75-mile radius of the worksite. FMLA leave could be used to deal with substance abuse disorders and related problems, including receiving treatment for opioid addiction, to receive treatment for another physical illness or incapacity that's related to opioid abuse, such as organ damage, or to care for a close family member who's undergoing treatment for those same conditions. FMLA leave may also be available due to an employee's lawful use of prescribed opioids if the employee's doctor determines that taking the medication as prescribed could render the employee unable to work. Absences because of an employee's unlawful opioid use that are not for treatment, however, are not covered by the FMLA. Critically, the FMLA also prohibits employers from retaliating against employees who request FMLA leave. For example, an employer may not terminate, demote, or refuse to promote an employee simply because that employee uses FMLA leave for treatment of opioid dependency. Now, while this podcast provided an overview of some of the major workplace considerations related to the opioid epidemic, it was by no means comprehensive. Each opioid-related situation can present a wide range of complex legal and practical challenges for employers. K&L Gates labor and employment and workplace safety attorneys are familiar with these challenges, and we can help employers navigate through the myriad issues that may arise. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at knlgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, knlgates.com. Thank you for joining us.